All right, good afternoon. What's up with the people? Really, I guess it's good morning. But say, I'm really, I got my new little setup, so I'm really just trying it out. I know it's a bit messy right now. I got all these wires and all these different things like that in the way. But I just really wanted to get my first little run at it, you know what I mean? So I hope all is well. I hope everybody is doing good. I hope everybody is doing well. And really today I'm gonna just talk about the entities, as you can see in the title. All right, just from a legal perspective, and then from there I'm just gonna proceed, and really I'm just gonna teach out of this book. I got this book right here, and we just gonna rock and roll. You know what I mean? But it's awesome. This is the shit that they don't want us to know. This is the shit that they do not want us to know. All right. And so we just gonna go through it, and I'm gonna get to it. All right. So, what is an entity? An entity is an abstraction endowed by law and most of the rights of a person. All right. The four entity types most commonly used in American business and discussed throughout this book are corporations, partnerships, limited liability companies, and limited partnerships. This book will explore the differences among them, but the initial focus will be on what they have in common. Statements about entities in the remainder of this assignment apply to all four types unless otherwise indicated. And just FYI for future reference, whenever you hear me make mention of an assignment, just in this book, assignment really is synonymous with chapter. So if you hear me say an assignment, it's just basically you can just plug in the word chapter. All right. So a business is an organization that sells goods or services in an effort to make profits. And again, guys, I know a lot of people don't like, um, I would say being read to, but I'm going to paraphrase a whole lot of the things in the book, where I'm able to paraphrase it. But whenever there are things that, where I need to speak verbatim, word for word, I'm going to do that as well. But we're going to make it interesting. This is an interesting book. And in this book is everything that we need to know when setting up a legal entity. I mean, you're going to be shocked and surprised by a lot of the things that you hear. I guarantee you. All right, so again, a business is an organization that sells goods or services in an effort to make profits. Now, check this part out. Businesses are often confused with the entities that own them. For example, even an entity's owner may refer to both the entity, for as an example, Joe's Restaurant Corporation, and the restaurant as Joe's Restaurant. Joe likely owns the stock of Joe's corporation, but it is the corporation that owns the business that serves the food. Did you catch that? So let's say you have an LLC, right? And let's say the name of your LLC is Joe's Restaurant. You don't own Joe's Restaurant. Your LLC owns Joe's Restaurant, and you just own shares in the LLC that owns Joe's Restaurant. Now, you can work for Joe's Restaurant and get paid through the LLC, but in all of this terminology, we need to know this. If we want to and take these LLCs and turn them into the magic they are. These are the things that we have to know. You can't run from this information, and you can't shy away from this information. You got to get it, because if you're trying to do business with another company or with another corporation, in which you can do if you magically activate your LLC, because corporations only do business with corporations, then you need this terminology. You know what I mean? When you go in and when you get ready to do business with them, if you don't know the corporate speak, if you don't know the proper terminology, then you're going to lose whatever deal it is that you're doing, because you're not going to know what to do unless you go do some additional research, or unless you find out what you need to know, in which I'm going to provide you guys with all of that. So I'm going to carry on. All right. So the deals that create businesses are deals among people. but the formal contracts that express the deals make little mention of specific individuals. That is, the contracts don't say that Sally and Bob will make the decisions. Instead, they say that the corporation's directors will make the decisions or that the corporation's shareholders will do so. They describe the deals in terms of entities and roles in those entities. The reason for ignoring the individuals in favor of the roles is that the individuals are expected to change over time. And that is because when you have a legal entity, such as an LLC, and I'll say it again, that's magically activated, those are my favorite words, then you could transfer, you can sell it. You can change, you can hire and fire and hire and fire, your board of directors if you choose to get one. If you grow and you get that big, or if you get investors and you decide you guys create a board, the board members will possibly change, will potentially change. And that's with any and all corporations. Because once you get an LLC, you have purchased a legal entity. So I'll say it again, all of this stuff that I'm giving to you guys, this is what's important and it's pertinent, and you have to know this information. All right. So let me see, where was I? All right. So the possible roles are innumerable, but each generally falls into one of three categories. Either you're an investor, and investors contribute money, property, or services that enable the entity to start, continue, or expand, or you're a manager. The managers make the entity's decisions. Officers, agents, and employees put those decisions into effect, guys. All right. So the legal term for roles, when you hear me talk about roles, the legal term for that is capacities. Just as the same actor can play several roles in a movie, the same person can participate in an entity in several capacities. So, for example, in a small business, the same individual might serve as the stockholder, director, the CEO, and the cook. Even in large businesses with thousands of participants, the same individual might serve in multiple capacities. So that is perfectly legal. It's perfectly legal when owning an LLC. One individual can play five, six, seven roles in a corporation as well. So, contrary to popular belief and contrary to the things that we've been told and showed, we've been told, oh, to manage a corporation, you got to have a board of directors. Oh, to incorporate your LLC, you have to have a board of directors, and you have to, it's a lot of red tape and all of these things. Well, you're going to learn from a legal standpoint, a lawful standpoint, the truth that they really don't want you to know, that just you can run the whole shebang bang. All right. So again, the legal term for roles is capacities. All right. You can serve in multiple capacities within your company or your organization. All right. So an entity is anyone or anything that the law recognizes as a legal actor. In addition to natural persons or human beings, entities include corporations, partnerships, LLCs, trusts, estates, associations, nonprofit corporations, benefit corporations, cooperatives, government agencies, and numerous others. When a natural person owns a business, the business is referred to as a sole proprietorship. The natural person will probably maintain a strict separation of the person's business and personal financial affairs. All right, and personal financial affairs through both record keeping and physical segregation, in which a lot of people don't do that. A lot of people don't do that with their LLCs. A lot of people don't do that shit with a lot of forms, especially if it's just one person running the whole show. And so that's another thing that I'm gonna hone in on real quick. Even if you operate your business as a sole proprietor, even if you don't have an LLC, even if you just hustling doing your own thing, always keep your business and your personal separate. Go and open up a separate account strictly for all of your business transactions. That way, if you ever did decide to get an LLC. It'll be a smooth transition, and you don't have to try to sort through all of your personal and your business finances from one account. You already know this specific bank account right here, I have always did business in, so I've got all of those records, and it'll make it very easy for you to transition from a sole proprietorship to an LLC, or from a sole proprietorship even to a corporation, because keep maintaining those financial records and keeping them separate is one of the pertinent keys to business, because you never want to mix your business and your personal. And you'll learn that once I get into the areas of into that area regarding the LLC and the corporation, really any of these legal entities. You always want to keep it separate, because there's this thing that I'll talk about later that's called piercing your corporate veil, or piercing the corporate veil. That's more corporate speak that in later assignments or chapters we'll discuss. So, and also for the record, I promise y'all, I promise, I'm in it to win it. I'm not going to do a video and then wait a month or wait 2 months or wait a week or not do a video. I'm gonna push this thing every single day. I'm gonna take an hour per day at least. I'm gonna dedicate an hour per day to following this book and pushing out this information. All right, so we're gonna cover it, assignment by assignment, or as I mentioned earlier, chapter by chapter. All right, so when a natural person owns a business, the business is referred to as a sole proprietorship. The natural person will probably maintain a strict separation of the person's business and personal financial affairs through both record keeping and physical segregation. That may enable the person to sell or transfer the business as if it were owned by a separate entity. As noted, however, a business is not an entity. The distinguishing characteristics of an entity are that it can own property, owe debts, enter into contracts, sue and be sued. In the eyes of the law, a business can do none of those things. The business owner, whether a natural person or an artificial entity, can. An artificial entity is an entity that is not a natural person. So, as the Supreme Court said of the corporation that owned Dartmouth College in Trustees of Dartmouth College versus Woodard, 17 U.S. 518 636 1819. That is citing a Supreme Court case. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. In most circumstances, the law treats artificial entities as persons separate and distinct from the people who participate in them. As a person, an entity owns its own property and owes its own obligation. All right. So, again, that's a beautiful thing. I'm hoping that it's not a lot of reverberation or a lot of feedback. I'm hoping that that my audio is good. If not, I'll do the replay, because this is my first time with the setup like this. I'm gonna get rid of all them wires and all of that. I'm gonna do all of that, but I'm hoping my audio is good, because I'm also running my phone in the background, which is how y'all see me on both screens, the avatar and then me sitting here. So I'll have to check all of that during the replay. All right. So now briefly, I'm going to talk about entity types and terminologies. Guys, each type of entity is governed by a separate statute. That is, each state has a corporation law that governs corporations, a partnership law that governs partnerships, an LLC law that governs LLCs, and a limited partnership law that governs limited partnerships. This book, as I mentioned, that I'm going to teach from, I'm going to break down from, this book contains references to two corporation statutes. All right. Very important that you guys remember these. The Delaware General Corporation Law of 2020. The acronym for that is DGCL, and the Model Business Corporation Act of 2016. The acronym for that is MBCA. It also will reference the Revised Uniform Partnership Act of 2013, also known as RUPA or RUPA, the acronym. the Uniform Limited Liability Company Act of 2013. The acronym for that is ULLCA. And the Uniform Limited Partnership Act of 2013, also known as ULPA. These four types of entities function in essentially the same way. The investors transfer money, property, or services to the entity in exchange for investment rights. The investment rights are specified in fundamental documents that contain the agreements among the investors and the entities. So, those fundamental documents, I'm sure you may have heard of an operating agreement. If you have an LLC, this is the fundamental document that the book is referring to. All right, the investors themselves may make the decisions. They may elect managers. Okay, so let me back up. Those fundamental documents, such as the operating agreement, they provide how and when decisions will be made and profits will be shared. The investors themselves make the decisions. They may elect managers to make some or all of the decisions, or the fundamental documents, such as the operating agreement, if you have an LLC, may appoint such managers. The operating agreement is very important, um, especially once you start operating your LLC in the capacity of a legal entity totally separate from yourself. Once you make that move, your operating agreement will be pertinent. It'll be pertinent that you keep it, that you'll have it on file wherever your business operates. Now, lawfully, it's not a requirement, but once you step crossover and you start doing business as a legal entity, a lot of the other companies, businesses, let's say you want to get an SBA loan, or if you want to apply to do business with the federal government. They will require that you have an operating agreement along with other documents, such as, they may ask for a copy of your meetings, your minutes. Although by law with an LLC, minutes are not required, um, it's still good to have those meetings. And if you're solo dolo, it's okay to have those meetings with yourself. You just want to have everything documented in a meetings folder per se. But we will get to that at some point in this book. I just kind of wanted to touch on it, elaborate on it, because that's one of the things that's also necessary. All right. So, despite their functional equivalents, talking about all four of the entity types that I mentioned, each entity type comes with its own terminology, with its own legal lease per se, its own legal speak, corporate speak. Each entity. Investors in corporations are called shareholders or stockholders, while investors in LLCs are called members. Investors in partnerships are called partners, and investors in limited partnerships are called general partners and limited partners. The investment rights are referred to as shares or stock when the entity is a corporation, interest when the entity is an LLC or partnership, and interest or units when the entity is a limited partnership. Any of these investment rights may be referred to as shares. All right. The fundamental documents, for example, such as the operating agreement for a corporation, are called articles of incorporation and bylaws. In Delaware, the articles of incorporation are called the certificate of incorporation. For an LLC, the corresponding documents are the certificate of organization and operating agreement. For a limited partnership, it is the certificate of limited partnership and partnership agreement. For each of those entities, the first of the two documents is filed with the state to create the entity. The second is held by the entity and its investors. The second being the operating agreement or the articles of incorporation and bylaws if it's a corporation. All right. Because partnerships are not created by filings with the state, they only have one fundamental document, the partnership agreement. Now let's talk about shares. Shares are contract rights entitling the investors to participate in the entity's decision making in specified ways. to receive distributions of money or property from the entity in specified circumstances or both. For example, shares of stock typically entitle shareholders to vote on the election of directors and to receive dividends when the entities pay them. Shares may or may not be freely transferable. Investors have three options for managing their entities. They can manage in their capacities as investors, they can manage in their capacities as managers, or they can elect professional managers. Now, there's their role, capacities again. Remember, capacities is the legal term for the roles that you're able to have within the organization that you own or manage. All right. For example, shares of stock typically entitle shareholders to vote on the election of directors and to receive dividends when the entities pay them. Shares may or may not be freely transferable. All right, so I went through that already. Boom, boom, boom. I kind of lost my spot for a moment. All right, so investors have three options for managing their entities. I believe I went through that. They can manage in their capacities as investors, they can manage in their capacities as managers, or they can elect professional managers regardless of the options chosen. Persons acting in the capacity of officers, agents, or employees will implement the manager's decisions. When investors manage in their capacities as investors, the arrangement is called shareholder management in a corporation and member management in an LLC. The shareholders or members don't hire anyone to manage for them or conjure up new titles for themselves. They just meet and decide. Perhaps because managing in the capacity of investor is so common in partnerships and limited partnerships, it has no name. Investors or others who work in the capacity of managers are called the board of directors in a corporation, the managers in an LLC, and usually the managing partners or the executive committee in a partnership. General partners manage limited partnerships. All right. Where we at on Facebook? Let me see. I'm gonna take a little few seconds to see if I don't know if I have anybody viewing or watching or not, but I'm gonna come over here and open up Facebook and see. Because my live should have went to Facebook as well. It should have. But Facebook's so funny style with me. I don't even see it nowhere. Nowhere at all, but that's all right because I'm gonna make sure I share it. I'm gonna make sure you get over here. But we're not on. All right. How many more pages do we have to go? All right. So I'm gonna get down to entity formation. Then we're gonna cut this short, and when I come back, that's exactly where we will start back off. All right. Where am I? All right. Hold on. Hold up. Hold up. Hold up. Hold up. All right. All right. So, for a combination of ideological and historical reasons, American entity laws impose few requirements on the entities, their investors, or their managers. Instead, the statutes state what appear to be requirements, but qualify them as applying only if the contract among the participants does not provide otherwise. So, in a nutshell, your operating agreement details how you're going to run your business. Your operating agreement should be fashioned as such. All right, you're able to do that. But if there's if your operating agreement, okay, so you have the law as well. So all of those laws that I ran off to you, each state has its own LLC law on how the LLC should be governed. If there are things that are not in your operating agreement, then you're going to have to follow um, how the law tells you that you should manage your company. So that's the take there. And whatever the laws are, whatever, you go through the laws, you can see what they are. See, this is why in a lot of instances, the operating agreements really cost a lot, because it, depending on your company, depending on your business model, depending on the laws, and how you want to manage your business, you have to go and find that within the law and then incorporate that into your operating agreement. And you can finagle it how and finesse it how you want to finesse it. All right. So if it's not in your operating agreement, then you have to follow the default rules, basically. All right. So the result is that entity laws operate in a manner fundamentally different from other statutes. When contracts conflict with entity statutes, it is usually the contracts that prevail. Statutory provisions that contracts can override are referred to as default rules. The policy for permitting override is to encourage private ordering. Private ordering extends to almost every salient feature of American entity types. The default rule is that a corporation is governed by a board of directors, but a corporation can be governed by anyone or anything it chooses, including its shareholders, a manager, another artificial entity, or even kings and queens. Partnerships and LLCs sometimes cause the investments they issue shares, and corporations are free to call the investments they issue interests or units. Among themselves, the rights of investors, managers, and officers can be whatever the parties agree, almost regardless of the entity type involved, as long as you have it included in your fundamental documents governing how your business is ran, how your corporation or how your entity is ran or managed. And I corrected myself because the business and the entity is not the same, as we learned early on. All right. All right. So although the parties could override most of entity law, they generally do not. Instead, most parties choose an entity type for its default features and leave most of those features in place. For example, participants who feel comfortable with the idea of a board of directors are likely to choose the corporate form. They could instead choose an LLC and specify that it be governed by a board of directors, but that might add complexity without serving any useful purpose. One result is that most entities with many investors are corporations, and most entities with few are LLCs. The participants in an entity nearly always enter into a formal agreement among themselves, specifying the terms of their relationship. To the extent they fail to do so, the default rules in the applicable entity statute determine their relationship. All right, in the appendix of this book will contain the certificate of incorporation and bylaws of Facebook. Hey, and the certificate of organization and operating agreement for BKG Catalina LLC. I may be able to read that or share some of that with you guys, but of course, I can't provide you with copies of it. But I may be able to do screen grabs or upload photos of it. And then when I get to that point where it's discussed in one of the assignments slash chapters, then when it becomes relevant, I will be able to show it. I won't be able to provide copies, but I'll be able to show it. All right. And the last paragraph here, then we're going to wind this up. Public companies are entities whose debt or equity securities are publicly traded on stock exchanges or other public platforms. Public companies are usually corporate groups. The group member issuing the publicly traded security is usually a corporation, but the issues are sometimes limited partnerships or LLCs, because again, depending on if you magically activate your LLC, you can manage and run your LLC as a C corporation, or you can also manage and run your LLC as a S corporation. It just depends on you. All right, and the plans that you have for your business. But for personally, um we hear a lot about generational wealth nowadays. Everybody's talking about generational wealth. Everybody's talking about things that they want to pass down to their children. And when it comes down to business, I'm gonna tell you, I'm gonna give you game right off top. If your company is not an a C corporation or at least an LLC managed as a C corporation, meaning that it's an entity totally separate from you. You've built it up, it's its own thing, everything is in its name, yada, yada, yada. That's the only thing that you'll be able to pass down to your kids unaffected. If you've got a business that's being managed as a sole proprietorship, or if you have your LLC and you're managing it as a S corporation, or you just haven't activated your LLC at all, and in that event, it's just a sole proprietorship. So in those events, um, it all boils down to that entity being operated as a sole proprietorship, or if you are a sole proprietorship and you haven't, um, you know, formed or started a legal entity. When you die, that business die. That's it. They ain't gonna be able to do nothing with it. Nothing. Nothing with the accounts. They're not going to be able to do anything with any of the contracts or any of that. All of that's going to end when they die. And then you'll have to redo everything, renegotiate everything. And that's why those forms of business are not generational wealth, because you cannot pass it down uninterrupted like you can the C corporation and or the LLC that's activated or operated or managed as a C corporation. I'm gonna give y'all so much game. Y'all just need to tune in. Y'all need to bear with me. Tune in. I know a lot of people don't like these type of videos where it's a lot of reading and a lot of information, but this is all of this information is what you're going to need. Let me see, did I finish that last paragraph? All right, so we're talking about public companies. All right, the group member issuing the publicly traded security is usually a corporation. I went through that, but the issuers are sometimes limited partnerships or LLCs. Entity statutes make no distinction between public and private companies. Federal security laws make the distinction and require that public companies make extensive disclosures of information through the SEC's or the Security and Exchange Commission website, EDGAR. All right, so that's the end. We're going to end there. We're going to resume with entity formation the next time I go live on it, which is probably going to be tomorrow. I'm going to, when I end this broadcast, I'm going to check the audio, see how all of that went because I'm using these headsets. I'm using these. So, but I do have a microphone here as well. So if the audio is not good on these headsets, if it's sounding hollow or like a robot reverberated whenever I go back and check the broadcast, then I'm gonna go ahead and start using the microphone. I'm gonna get that set up. I know this is gonna sound good right here. I've used it before, but I just wanted to try with these headsets because with the avatar, they say that the headsets work really, really well. All right. All right. We're going to end this broadcast. Let me sit down here. I'm going to holler at y'all good people tomorrow. Y'all have a good day. Be blessed. And stay blessed. Be a blessing. The whole nine. Look at me. I'm over here trying to work this one when I got to be working this mouse. All right, y'all. I'm about to end the broadcast. Y'all have a good day. Peace. And we're going to get deep on a whole lot of other subjects too, not just business. So y'all pay attention to my lives. I'm really going to be giving out a whole lot of game, a whole lot of how-tos, a whole lot of on all of that, covering it all. And I'm going to be doing it every day. So y'all might as well get used to me, man. I'm trying to go on. I've been on this live stuff and working with these computers and doing all this graphic design and all of that ever since 2017, man, 16, 17. But I haven't just put it down every day. But I'm in it to win it now. So I'm going to catch y'all next time. Be safe.